Hey everyone, Harry here to talk about the affirmance by the Second Circuit Court of Appeals of the verdict in favor of E. Jean Carroll in the defamation and sexual assault case against Donald Trump. You may remember the Carroll cases have had a little bit of a tortuous history. She first brings a defamation case, and that case gets caught up in a whole legal maze of what is the proper law, and was Trump immune when he made the nasty comments about her as president on the White House lawn? I don't know her, she's not my type, all that stuff. While that was winding its way through the courts that eventually decided he was not immune, this second filed case went forward, and it was the first one to go to a jury verdict. And it also added by then a count under a law that had just passed in New York that permitted victims of sexual assaults from long ago, gave them a 1-year window to reopen the claims. And that's exactly what E. Jean Carroll did. So she sued for both the assault in the Bergdorf Goodman dressing room in, I think, 1991, and the defamation, which Trump had conveniently repeated after he was no longer president. So it wasn't even a question anymore of is there immunity, whatever, the issue that was holding up on the first filed case. So this goes to the jury. They come back, $5 million. This is the one that Trump actually sued ABC and Disney over, because George Stephanopoulos said in an interview with someone else that the jury had found rape, and it in fact hadn't needed to and hadn't found rape, but just went on to find sexual assault because that was all that was necessary to make the case under the New York law. Anyway, that's just to remind you that's really neither here nor there. So she wins the case, and Trump files his normal strident appeal that this is the end of civilization and the law as we know it. And the Second Circuit, which is the Court of Appeals between the trial court, Judge Kaplan in the district court in the Southern District of New York, Second Circuit, and above there is the Supreme Court. The Second Circuit affirms it unanimously, and in pretty sort of back of the hand fashion. I mean, they go through everything, but they really don't break a sweat. And if this weren't the case involving Trump, it would really seem quite pedestrian. It is the case involving Trump, though, and it's not pedestrian for a few reasons. Not simply that E. Jean Carroll wins, which is a strong augury for her to affirm her second, much higher liability verdict in the other defamation case, but also what it says about Trump, the president-elect. So really what Trump claims on appeal and what the Second Circuit decides is a series of evidentiary questions. But the key ones have to do with special rules under the Federal Code of Evidence for prior acts of sexual misconduct by a defendant. So in a normal case of fraud or bank robbery or you name it, you typically can't put on evidence that the defendant did something similar before. You can maybe frame a theory that will permit you to do it, but typically it's considered quote unquote propensity evidence. That is based on the inference, well, he did it before, so he'll do it again. He's a bank robbing kind of guy or a fraud committing kind of guy. That's usually forbidden in the Federal Rules of Evidence, except for sexual misconduct. There are a couple rules of evidence that permit prior acts of sexual misconduct to be introduced where the same kind of conduct or similar enough is at issue in the current case. And that's what happened in the Trump defamation case, where Judge Kaplan, Trump, defamation and sexual assault, importantly, as she brought claims for both, and she was permitted to introduce this prior 3 or 4 episodes where Trump had groped or, just engaged in completely unwanted, essentially assaults on women that he didn't know or hardly knew. Here is the let me give you the sort of itemization of what we're talking about. So there was a woman, Jessica Leeds, who said she was just assaulted by him on an airplane, had a flight attendant invite her to come sit with him in first class, and he just basically pounced on her, grabbed her breasts, etc. That came in. Similarly, a reporter for People magazine said she went down to Mar-a-Lago, and he took her to a room to show her a painting, and just boom, he pushes her against the wall, starts kissing her, etc. And then finally, the judge permitted the jury to hear the infamous Access Hollywood tape, in which Trump boasts about just grabbing women by the genitals, boom. And as the Court of Appeals said, because as I said, the law permits the prior acts to be introduced, but it's also subject to a kind of override if the prior acts are going to be very prejudicial and not very probative. But here they said, no, they're very probative, because the acts, and this is kind of a real headline here, are sufficiently similar to show a pattern or recurring MO, modus operandi. And basically, in all of them, Trump first engages in ordinary conversation with a woman he barely knows. That includes E. Jean Carroll. Then abruptly, this is their words, lunges at her in a semi-public place and proceeds to force himself, on the woman and kiss or other, obviously with E. Jean Carroll, it's much more serious conduct. But the court says that's solid under these rules, 413, 415, and therefore it's admitted. And that's the most important part of the case legally. It's also the most important part of the case politically, factually. You have a Court of Appeals just under the U.S. Supreme Court basically saying the president-elect is an adjudicated recurring sexual assailant in this strikingly gross and nasty way of just talking with women and then boom, just assaulting them. That's who the president is. That's been determined, and it was perfectly proper to admit these prior instances of it. That's who the guy is. And indeed, that's who the guy is. Trump is fighting so hard to try to make all the criminal stuff go away, as if he has a clean bill of health somehow from the American people, but not so. Besides, the criminal cases that have gone away for reasons having nothing to do with his guilt or innocence. There are these civil cases, and they establish, here's your president, America, a basically recurrent sexual assailant who has this really, gross, nasty, and sort of high-handed MO of just talking nice a little bit and then boom, kind of as the Access Hollywood tape goes, grabbing them. So that, I think, it's legally, it's noteworthy. They just basically, march through it and don't have much trouble finding it. But then just politically, historically, here is Donald Trump, the once and soon to be future president of the United States. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.